Hey guys, this is the second video in this series called Breach of Contract. In this video, I'm going to talk about repudiatory breaches. Now, repudiatory breaches can fall into three categories. The first is renunciation. What is renunciation? Renunciation simply means I don't want to do it, okay? The party, the contract says, no, I do not want to do it. Number two, impossibility by one's own fault. That means a party to a contract, by his own doing or act, okay, he makes it impossible to fulfill his contractual obligations. The third category of repudiatory breach is failure to perform the contract in accordance with its terms, or not performing at all, totally not performing at all. So these are the three categories under the umbrella term repudiatory breach. The Singapore High Court in RDC Concrete Pte Ltd and Sato Kogyo Pte Ltd stated that there is no automatic right for a party to terminate a contract, to cancel a contract in the event of a breach. Only repudiatory breaches, okay, grant the innocent party the right to choose whether to terminate, to cancel the contract, or to continue the contract. In other words, to accept the breach but to allow the contract to continue. If he does not cancel the contract and he affirms the contract, then the contract continues and both parties must continue to perform their obligations. The court in RDC Concrete also laid down three different situations of breach of contract. They are called Situation 1, Situation 2, Situation 3A, and Situation 3B. I will be discussing each of the situations in detail in separate videos, but I'll just briefly go through them in this video. Situation 1. This applies where the contract clearly states, okay, that upon the occurrence of an event, one party can terminate the contract. For example, in a contract for the supply of teak wood, okay, the contract states that the supplier has to supply grade A teak wood. If the wood supplied is not grade A, then the buyer has the right to immediately terminate the contract. This is situation 1. Situation 2 for repudiatory breaches deals with renunciation. As I mentioned before, renunciation is where a party to a contract by words or conduct, or sometimes even silence, tells the other party that he will not perform his obligations. And under such circumstances, the innocent party is entitled to cancel the contract. This arises not by non-performance. It's not because the defaulting party did not perform his obligations, but it is the manifested intention not to perform. He shows by words or conduct that he does not want to perform his contract. This is also sometimes called anticipatory repudiatory breach. Anticipatory means before the time has come for performance, he shows that by words or conduct that he does not intend to fulfill his contractual obligations. Situations 3A and 3B deal with repudiatory breaches arising from failure to perform, either where the defaulting party completely does not perform his obligations, or his performance is delayed or late, or sometimes the performance of his obligations are not up to scratch, for example, defective quantity or quality. To give you an example, if the buyer enters into a contract to buy 100 teak tables, okay, and the supplier delivers 98 teak tables, that would be a breach under the situation 3 category, because It's a difference, it's a breach relating to the quantity. Alternatively, if the supplier delivers 100 oak tables, which are totally different in quality, then that will also be a situation 3 breach. Unlike situation 1 and 2 repudiatory breaches, which can be anticipatory because it happens before the time for performance has come. Situation 3A and 3B breaches are always actual breach because the breach occurs when the time for performance has arrived. So thanks for watching this video. Stay tuned for the subsequent videos I'll be making on the other categories of breaches.